Hello, this is Karen Fronek with Assignment 2, Research Case Study on Defamation, New York Times Company versus Sullivan. The two parties involved in this case is LB Sullivan as the plaintiff and the New York Times Company as the defendant. LB Sullivan was one of 3 elected commissioners of the city of Montgomery, Alabama. In his role as the Commissioner of Public Affairs, his responsibilities included supervision of the police department, fire department, Department of Cemetery, and Department of Scales. Sullivan's complaint alleged that he had been libeled by statements in a full-page advertisement that was carried in the New York Times on March 29, 1960. The advertisement was titled, "Heed Their Rising Voices." The advertisement described a certain, quote, wave of terror that was taking place in Montgomery. Sullivan felt 2 paragraphs in particular from the advertisement were defamatory. They were, paragraph 3, quote, "In Montgomery, Alabama, after students sang 'My Country 'Tis of Thee' on the state capitol steps, their leaders were expelled from school, and truckloads of police, armed with shotguns and tear gas, ringed the Alabama State College campus. When the entire student body protested to state authorities by refusing to re-register, their dining hall was padlocked in an attempt to starve them into submission." And then in paragraph 6, quote, "Again and again, the Southern violators have answered Dr. King's peaceful protests with intimidation and violence. They have bombed his home, almost killing his wife and child. They have assaulted his person. They have arrested him 7 times for speeding, loitering, and similar offenses. And now they have charged him with perjury, a felony under which they could imprison him for 10 years, end quote. Notice that neither of the statements mentioned Sullivan by name. Sullivan's claim was particularly focused on paragraph 3's terminology in regards to the reference to police. Sullivan felt the remark about forming a ring around the campus as well as the padlocking of the dining hall in order to starve the students into submission were defamatory. And in paragraph 6, Sullivan was offended by the repeated use of the word they. They have arrested Dr. King 7 times, and they who did the arresting would be equated with the they who committed the other above described acts and with the Southern violators. Sullivan argued the paragraph would be read as accusing the Montgomery police, and hence him, of answering Dr. King's protests with intimidation and violence by bombing his home, assaulting his person, and charging him with perjury. Sullivan and 6 other Montgomery residents testified that they read some or all of the statements in the advertisement and that they directly referred to him in his capacity of the commissioner. Interesting is even though many of the facts were not accurate, such as the students sang the national anthem, "Not My Country 'Tis of Thee." 9 students were expelled, but not for leading the demonstration, but rather for demanding service at a lunch counter at the Montgomery County Courthouse on another day. Students did not refuse to register, but boycotted classes. Campus dining hall was not padlocked on any occasion. Police never formed a ring around the entire campus. Police were never called to the campus in connection with the demonstration on the state steps. Dr. King had not been arrested 7 times, but 4. Dr. King's home, although bombed twice with his wife and child, were at home. Neither of these occasions happened during Sullivan's tenure. And finally, Dr. King had been indicted on 2 counts of perjury, each of which carried a possible 5-year sentence, although Sullivan had nothing to do with procuring the indictment. Another fact is that Sullivan made no effort to prove that he suffered actual punitive loss because of his alleged libel. The Times Advertising Acceptability Department accepted the ad, and a letter that certified the person's names appearing on the advertisement as sufficient proof of authorization. There was no knowledge of anything in the ad as being false. The Times also sent a letter to Sullivan, quote, "We are somewhat puzzled as how do you think the statements in any way reflect on you, since his name was not mentioned." There was no retraction of the ad. The circuit court, the lower court, awarded Sullivan's damages of $500,000, the full amount claimed, and the New York Times Company appealed the case, and it went to the Supreme Court for review. So why did Sullivan feel his reputation was damaged by the New York Times publication? According to Carla Gower's book, Legal and Ethical Decisions for Public Relations, a defamatory statement is one that holds a person up to public hatred, ridicule, or scorn. Individuals can be injured in a defamatory statement in 3 ways. Their reputation can be damaged because a statement lowers them in the eyes of others, making them think less of them. 2, they can be deprived of the right to enjoy social contacts because people shun them. Or 3, their ability to work or hold a job can be impaired. In my opinion, Sullivan felt his reputation was being damaged by the accusations that the police were being too aggressive, and that he personally directed and approved of each of these individual events that were stated in the advertisement. The New York Times Company versus Sullivan case brief says, quote, "We think it is common knowledge that the average person knows that municipal agents such as police and firemen and others are under the control and direction of the city governing body, and more particularly under the direction and control of a single commissioner." End quote. Sullivan, therefore, was afraid of being pinned as the single source of the negative actions enforced by the police department under his watch. Sullivan was concerned about his reputation and possibly his political standing for future re-election efforts. Does a plaintiff need to be specifically named in the publication, or can identity be inferred? The person does not have to be identified if enough details are given that point directly to a specific person. What must a plaintiff show in order to prove libel? In order to prove libel, the plaintiff must prove all 6 essential elements, which include publication, identification, defamation, fault, falsity, and injury. According to the ruling at the Supreme Court level, these elements were not proven in New York Times Company versus Sullivan, especially in regards to malice or ill intent. What was the Supreme Court's decision? The Supreme Court reversed and remanded the lower court's rulings, which means the Supreme Court feels that the lower court, in this case the Circuit Court, made an error, and the judgment therefore is reversed, meaning the lower court reached the right result for the wrong reason, therefore invalidating the Circuit Court's decision, and remanding, meaning to send back to the lower court for further determination on the facts of the case. How can you relate what you've learned from the Sullivan case to your future work in public relations industry? Well, the New York Times versus Sullivan case has many interesting lessons. First and foremost, libel is written defamation of a person's character. Secondly, libel is the publication of a false statement about another person that causes that person harm. Burden of proof is on the plaintiff. You must be able to prove the 6 elements of publication, identification, defamatory statement, fault, falsity, and injury. I also learned that I would want to avoid defamation claims by understanding its importance. Become a defamation watchdog by pointing out possible areas of concern for clients, which would help to avoid litigation in the future. I would also like to say that using proactive strategies to avoid defamation issues, including sound journalism techniques, make sure opinions are backed up with facts, keeping quotes authentic, avoid innuendos and suggestive implications. Be careful when using clippings and news sources that they are void of defamation. Use honest headlines. Don't hype your headlines. Archive interview notes and rewrite any content that could be viewed as libelous will help in avoiding litigation. Overall, PR professionals can be the first line of defense for libel claims as they're constantly scanning the media for information about themselves and their clients. Being knowledgeable about the consequences of harming others' reputations is an integral part of the public relations professional's toolkit. Thank you very much.